Okay, welcome. I'm glad you're here. This is the Small Claims Court Process Seminar. My name is Victor Wade. I've been practicing law, basically a civil practice, for 39 years. I mean, I'm coming up on my 40th year right now. And as a civil lawyer, over the course of the years, I thought I wanted to be a judge and things like that when I was young, and I'm glad I never got the offer to be a judge because they work like dogs over there in these courts now. They just have heavy loads. But anyway, so I thought, well, how am I going to satisfy my desire to be this judge? And I just said, well, I'll apply for the Small Claims Court pro tem representative and being a judge that way. So I've been doing that off and on approximately 30 years. I just volunteer to my profession twice a month at the Small Claims Court, unpaid. I have to be certified. I take courses every 3 years, I believe it is, to be re-licensed in effect or re-programmed to be a Small Claims Court judge, although after 30 years you'd think you've seen everything, shouldn't make any decisions almost. And believe it or not, I told Laura, told Nora, the director here, a little story some time ago about we haven't seen everything, but I'll leave that to maybe to the end or something else. So and I've had some very interesting cases over there. People come with very interesting problems to the Small Claims Court. Problems that I thought, these will just go away eventually. No chance. When you're young, like I was at that time or one time, I thought, don't people learn? They're back there again. I can't believe it. But as I've gotten older, we just have the same patterns of people that come through and with some new little twists. In addition to the documents that the director of this program provided to you, I also provided, it's on your desk, just to kind of alert you to what's happening in the Small Claims Court. There's a 3-page document. It's a fee schedule. Boy, are they really trying to drive that place with fees. The judges' retirements want to be paid. This is how we do it. And then, in addition, the second page is what's called an authorization form. So if you represent a corporation, a partnership, a homeowners association, or maybe a law office, you have to sign this authorization to allow the court and to advise the court that you're representing this legal entity other than yourself. Typically, the Small Claims Court process is for individuals, but believe it or not, legal entities like corporations, partnerships, associations can all practice there as if they were individuals. And including the city of Sacramento, I looked at 40 cases day before yesterday for them. Bam, 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 they just went that quick. I can't remember what those fees were for, some services that the city provided. City, state, county, water district, park district, all those are legal entities and they can come into Small Claims Court and file a claim on behalf, but they have to sign this representation form that they're authorized to represent that agency. In addition, you have one more page. It's called the itemization. And the itemization, for when you come in and you have different categories of damages, or these are what you've spent your monies on or whatever to recover yourself, we want you to itemize it. Give us the math. Most of us lawyers couldn't do math in a million years, but if you make us do it, it gets to be a grind. So I'll just say, okay, you don't have your, if I was in the courtroom and I'm judging that day, I'll just say, in effect, you don't have your itemization done, please take it into the courtroom and I'll make your case come last and hear everybody else because it takes too long. You need to know that in our Small Claims Court, and by the way, that is at, I think it's Bicentennial, you need to know that our Small Claims Court is at the corner of basically Howe Inn, Power Inn, it comes into that area, and Folsom Boulevard. And if you're driving west, let's see, south on Howe Avenue, it'll be on your left-hand side. It's a big white building. It looks like a mausoleum for a crematorium as far as I'm concerned, but that's what it looks like to me. But that's where it is. So you just go down Howe Avenue, take a left on Folsom, take a left on Bicentennial at the first light, and you're almost there. And boy, they're raising the parking rates out there too. They just can't get away from raising the money, raising the money. But, so, do your itemizations if you're going to represent yourself. Now, can a lawyer come in and represent himself? Yes, I've done it. I've represented myself on several cases. Do we win all the time? No. I've lost a couple of cases over there. I've lost a couple of cases on appeal. Should I have settled it? Yes. Duh. I should have settled it. I have a little speech that I kind of give to the participants in the audience. When I come on the bench, I'll ask them, have you tried mediation? We have experienced mediators out there, wonderful people, knowledgeable people. So what happens is, you're all, and most of the time, all of you have been out to mediation, you've been brought back in ready to go to trial. You couldn't mediate the case, you couldn't settle it. But anybody that wants to mediate a case again, a second time, during the course of the classroom, or during the course of the court calendar, I will allow them to go back out and mediate again. And if they may just reach a settlement, who knows? While the calendar's going in, then they can come in right at the end. So it's very important. And I try to advise the plaintiffs, or the parties, if you will, why you should mediate, because none of us are perfect. Humans designed it. It sometimes fails. People cannot, they don't understand the same words. So, anyway. So, itemize, if you will. Now, to file, I want you to look at the fee schedule just for a minute. To file a small claims case that's under $1,500, I believe, $30 filing fee. If you're filing 12 or less cases in a year. So that means the telephone company can come in and file in the new calendar year 12 cases. It'll only cost, if they're under $1,500, it'll only cost them $30 a piece to file. Somebody have a file? Oh, let's see, it must have been that judge I used to know. Used to tell everybody in the courtroom, hey, phone's working? Out the door, or I'll throw it out. Oh, I wonder who that guy was. Filings for fewer claims, that's all right, Bob. That's why we got along all years ago, so we understood each other. Don't you worry about it. I love to tease everybody. Filings for 12 or fewer cases that have a claim of $5,000 or less, $50. You can see what's happening here. And telephone companies or utility companies or city governments or whoever have claims that are in excess of $5,000. A lot of people have claims in excess of $5,000. So it's going to cost you $50. If you have a claim for $7,500, 12 or less in a year, it's going to cost you $75. Now, have you noticed about these claims here? If it's a $5,000 claim, it's a $50 fee. Do you see something about that? I say they would think, oh, well, we'll just set it at $50. It rhymes with the number for $5,000, right? Well, they must have done that for the $7,500 claim because the fee's $75. Anyway, and if you have filed more than 12 small claims in over the past 12 months, then your filing fees are $100. Now, who files that many claims? Your large corporations, finance companies, leasing companies, governments, somebody that's taken an assignment of claims. There are companies that will take an assignment of judgment claims or our claims, and that by that reason of that assignment they can go in because they own the claim. They bought the claim. I have done that myself. I will buy a claim if it's right price, and I'll go take it myself, because I've already made the odds in my mind are that I'll either settle it or win it. Probably. So remember that a bird in the hand's worth two in the bush. Always. Always. Don't be dumb like this lawyer was and lost a couple that way for failing to settle. Can the defendant file a cross complaint? Yes. The fees are the same. So it's conceivable that you could have two claims coming in at the same time. Okay? And I'll tell you about a couple of cases later. My examples today will be two basic examples. One for a breach of contract and one for negligence, like in an auto case. Breach of contract, you loaned somebody $1,000. You thought it was your friend, right? And you had them sign a little stationery store promissory note. Comes time to repay with that interest. Hey, John, where's my money? Oh, I don't have it, this blah, blah, and it goes on and on and on. You finally get up to here with his excuses, and you come and file a small claims court for a breach of contract for $1,000 plus your interest plus costs, okay? With the auto accident case, That kind of a case is based upon typically a negligence claim. You would come in and file a claim for the damages that you have, which could consist of auto, medical, wage, maybe personal injury, or maybe pain and suffering. You need to have all of those documents ready to go for me to look at. Same thing in the breach of contract case. So I'll try to refer to those two cases. Types of cases over the course of this seminar. If I'm speaking too fast, just tell me, because sometimes I tend to speed in these things. My two daughters who had a lot of piano, they used to speed, and I'd catch them at it and say, hey, slow down. So, all right, now, one other aspect of this whole area seminar, I want to kind of put you into the courtroom before I get start into the documentation. Over there in that big building, they have small claims, they have traffic, and they have unlawful detainers, which is where the landlord is kicking everybody out, trying to kick somebody out. On a Monday, they'll have 1,500 people go through that court. It's heavy. Parking lots are full. You're trying to find something, and you don't want to get tagged for a ticket. Day in and day out, you come over there, you'll see motorcycle cops, taking up a whole thing. Here's a few highway patrol cars. I mean, they're over there basically as witnesses for the people. So it's a heavy, heavy court. And you do not clear security over there unless you making sure that you have all the metal off of you. Run it through the sheriffs over there are very meticulous, and they're about there keeping people safe. It's a nice course. It's a nice building over there. Now, you've got your case. It's either at 8:30 or it's at 1:30. You filed it. I want you to come prepared. So before you even get to that courthouse, you need to put all of your documents in a sequential order. Think if you're putting it to an 8th grader. If you're going to write a letter to an 8th grader about this case, you want to just kind of lay it out with a little summary. The same thing would occur for the defendant, assuming that you got them served. They need to lay out their case so I know what their defense is. So you're going to make not only have a set of documents for yourself, you need to come prepared with a set of documents to give to the other side at the time that you mediate the case out in the hallway before you have your hearing in the courtroom, assuming you do not settle this case. You also need to have a copy for me, because if I don't have a copy, I guess I have nothing to rule on, right? And every case that we have is almost all documentation. You don't bring in a binder that thick for me to read in 10 minutes. And people do that with that many pictures. Honest to God, I just think, hey, this is not Judge Judy's court. This is not Judge Wapner up here. This is real life, and we got to go through that counter just like that. So, organize it, keep it to the minimum, what you think is relevant, and I'll make the determination what to throw out, all right? You present your documents to me. Now, let's assume that you're going to come up to, I call your case, you come up to the two podiums. Over there in that court, the plaintiff is here, the defendant is here. Do you know how the word plaintiff came about? It comes from the word complain. P-L-A-I-N is plain. Tiff is an old English word meaning that I have a tiff with Bob Schley over here. Means like a little argument, or I have a beef with him. The word tiff. So they joined those two words to call plaintiff. All right? Defendant obviously is pretty obvious that you're defending the case. All right? So you come up. The bailiff typically will come in between, and boy, you don't want to tick off the bailiffs. No talking in the audience. And you will sit outside for a little while. But we have good court attendants over there. They've been trained to understand people and what to react and what not to react and when to call the sheriff from downstairs and so forth. I've had cases where we called the sheriff, said, sheriff, got to take them out because they just get dangerous. And we have had some dangerous situations over there. And they do have a jail cell over there that will hold at least 4 people downstairs. So, you know what? You may be cooling your heels in that jail cell if you're not respectful, basically, or exercising a little common sense in that place. Anyway, you come up. The bailiff will have you sign that you authorize me to act as a temporary judge, and so that I can go forward. I don't get paid for this. I'm just trained to do it over a course on this continuing education. Plus, I got a bit of experience there. You'd be surprised. People say, "Oh, I don't like the way that guy looks," and they'll refuse. If they refuse, then the clerk will call for a real judge that gets paid, and they'll send those set of people over to the next court, typically, and we'll take one of their cases as a substitute. We're running 2 courts at the same time here. And before we even go, the judges go into the courtroom, we get to see the cases on the computer screen to see if we know anybody, if we've had any discussions with any of these people. So, and if I know anybody, I send them to next door because I don't want the appearance of an impropriety. And I do know a few people who have been living here since 1966. So I run across people. Or the other way I can do it is I can advise the other party that I know somebody, one of these parties. And I can tell them, these are the circumstances, how I know them. Now, you know that. Do you still want me to hear the case? Some people do, some people don't. Okay. So you come up here. You've given me, or the bailiff has given me your sets of documents. Be nice to each other. You don't talk to each other as between you talk to me. Okay? Because if you talk to me, then we're going to get down the road with this thing. So that's the basic way the courtroom is. So while we're going down through this seminar material, kind of have an idea of where you're going to end up after you have filed and started your action. All right? After you have loaned that $1,000 worth of money, after you've had that auto accident that somebody just smashed your car up and you too. Can you bring a claim, by the way, for more than $10,000? I mean, for more than $7,500? Yes. You can bring that kind of a claim. But you don't get a judgment for $10,000, assuming you're right. You only get a judgment for $7,500. We cut off the top. Do corporations, is this a typical tactic of a corporation? Yes. They'll cut off the excess right off the top just so that they can come within the brackets, the principal brackets that the court has set forth, and oftentimes to save money on the filing fees. You know, if you take the difference between $75 and $50, they're going to take the $50 fee and just cut the case off. $50 fees for a $5,000 claim. It's less than $12 in a year, and they've got a $6,500 claim. They'll just lop off the $1,500, charge it off, basically. So now we are set. Let's talk about who can file. You can file. Hey, by the way, has anybody filed a small claims case in here? You have. What was your, in this county?
Yes.
What was your experience? Were you a plaintiff or defendant?
I was a plaintiff.
Okay. So you initiated the action. Regardless of what kind of a result that you got, you received, what was your basic experience? Was it timely? Was the process probably longer than you anticipated before you got to the court hearing?
It was actually very efficient.
It was good. Loved it.
Several actions that
Oh, okay. Okay. I saw someone else raise a hand up here. Been in small claims court?
Oh, yeah.
Which side?
I was a plaintiff.
Plaintiff? What was your experience with it?
And it was pretty efficient, too. We got, maybe took about 2 months.
Okay. All right. This is a very good court here. We have excellent small claims courts. Our court system here in California is not corrupt like it is back east. We move cases through, they move bundles of cases through. Courts, do not have time to be involved in corruption. It's just, it takes more time to be involved in that than to do the cases. So, and they don't have any access to grind, as a general rule, until you tick somebody off, and you tick them off so bad that you're embarrassing them. Well, guess what? You're going to get your case put to the bottom of the calendar, or the judge may just talk to you out of the presence of everybody else, because we try to be courteous to each other. Because we got to fight. We have this legal boxing ring that we have. We have rules of evidence that control the lawyers and the people in this legal boxing ring. remember, it's best to settle. All right. I've got experience there. All right, who can file? You can file, corporations can file, partnerships can file, homeowners associations, any legal entity, including government agencies. Everybody gets a chance. And by the way, in every county in the state of California, and we have 58 counties, there is a small claims court. And the small claims court is a department of the Superior Court. I go back to the old days when we had justice courts. Even here in Sacramento, we had justice courts. But as the cities grew, they left the justice courts out into the hinterlands and created what they called municipal courts, which are city courts. So you know, depending on where you filed is where you went. Now, in the I guess the idea of saving money or whatever, they merged the municipal courts and the superior courts in together, where the superior court, and you only have one per county, but maybe 100 departments, and they renamed the smaller cases for the small claims department, and they called it a department of the Superior Court. Where do you take your appeals, by the way? To the Superior Court from the small claims court. And in that kind of a situation, if you have to appeal it, you get a retrial on the whole facts. Oftentimes you get defense, they don't even appear because they know that they can appeal. Because in a plaintiff versus defendant, plaintiffs do not have the right to appeal. You lose, you lose. You win, you win. Defendant loses, they get to appeal. Or they don't appear, they can still appeal it. Okay? So it's designed a little bit to cut the process down, but be fair. And at the appeal level, you get to have the second bite of the apple. Put on your whole case again. Way it goes. So, in this county, we file our small claims court cases out in Carroll Miller Justice Center. How does the defendant find out about the claim? This is what happens. You file your small claims action. We're going to make you the person who loaned the money, and we're going to make you who were on the short end of an auto accident. Okay, so you're the plaintiff. So you go to the small claims court, fill out the paperwork. You can do it online. I'll talk to you about that in a minute. Or you can do it via I think they have some typewriters there. And if you need assistance, they have a legal clinic there, a small claims court legal clinic. Very good people that can give you some kind of advice on how to take care of the paperwork. Right there. And that's typically the mediators that do that service. So you go there, you file the paperwork, you've talked to the legal clinic folks here, they've advised you to file a claim for $7,500 or whatever. You now have this document. Well, how does the defendant over here get notice of it? Because in the United States we have a concept called due process. Defendants are entitled to be notified of any action against them. Service of process then comes. Well, how do I get, you can't do it yourself because you might come into my courtroom and lie. Oh yeah, I served a judge. Sure you did. I can't trust that. I have to have, by statute, a neutral person that would have served this paper. Now you can do it by certified mail. And by the way, I see there's a court charge for in here, so the court will send it out to certified mail on the last address. All right? So it'd be the filing certified mail fee plus the cost of the certified mail. So that takes you, and you got your court date, by the way, and you would have had it probably about 30 to 45 days out. Okay? If you don't want to do it that way, you can have the sheriff do it. So you bring it down to the sheriff's office. Now, in some counties, they're no longer doing that because the sheriff's department are just overloaded. Too many actions. They'll tell you to go to a private process server. Or you can go to a licensed process server. They'll probably charge you, let's say, $30. So now you got $30 filing fee. You got that little bit of time off work. I took a couple hours off early. You've got this service process fee of $30 if you do it by private process server. The sheriff's going to charge you the same amount. But the difference between a private process server and a sheriff is the sheriff's got a gun on his hip. That's kind of enforcing, I think. So anyway, if you have, or you can use a family member or a friend, somebody that doesn't have any interest in your action. any legal interest at all. And they have to fill out what's called an affidavit or a proof of service. If they get it served and they fill it out, they fill out that proof of service, they then take it back to the small claims court, or they may give it to you to file back with the clerk's office at the court to show that the clerk, show the court that you have jurisdiction on this person, that you've got them by the neck. If you get a non-estus return or a non-return on the certified mail, you need to follow that up with the clerk of the court to see if the little green card came back or the whole package came back. If it did, you need to get an extended court date and take a different method of service. I would just use a licensed process server, and there's all kinds listed in the phone book. But they have to be licensed. Now, if you're going to use a friend or family member, and they need to make sure that they fill that declaration out, because if it's not filled out correctly in that declaration, we're sticky about that. So they need to take their time. How much time ahead of the action do you need to have? In this county, I believe it's 20 days. If it's out of county, it's 30. So let's suppose, and then we have what's called a subserve. We serve somebody else at the premises or their office or whoever. If we have made a diligent effort, if the process server has made a diligent effort of 3 or 4 times of trying to serve the individual you're trying to serve, okay? That's called a subservice. So the subserver guy needs to fill out the declaration of proof of service plus the declaration regarding the subservice that he or she attempted to go to locate this person, and then that all gets filed back with the court. So now we have a filed legal action. We now have a process, a declaration on file with the clerk of the court. The clerk now can put this in the system that this case is a go. But don't forget, the defendant can cross-complain back against you. In the automobile case, that's pretty easy to do. You just sue them back. I mean, that's typical. In the promissory note case, you could sue them back, but you might get ragged about that by the judge because you didn't have an adequate defense as to why you couldn't pay. Now, you couldn't say, well, listen, I was on methadone that day, that's not right. I was on amphetamines. No, that's not right. What is that? Meth that day, and I just didn't remember it. Too bad. You lose. You can't use an excuse like that to say, oh, well, I didn't have the intention not to pay. Give me a break. All right, now, so you could have a case where you have the defendant crossing back, maybe for the same action. Maybe the defendant might say in the contract, well, I paid that lady back. And now I'm going to sue her for the inconvenience of me coming to court and so on, and whatever. All right? So, there's some interesting things that you can do, or a judge can do, with cross complaints in civil actions. And I'll bring up a couple examples towards the end. Okay, so let's assume for the moment in our little scenarios of things that the defendant has cross-complained back about, and maybe for close to the same amount of money. Okay, all right. So we've covered the small claims court jurisdiction and the rules. By the way, they're simple and they're informal over there. We will not hold you to some kind of a standard that we judges may hold lawyers to. It's just something that's not done, because this is a small claims court basically for the people. This is where they can come and get their redress. This is where we have little disputes, or big, depending on your view, big disputes about money. Or how about the person that puts up a antenna dish in your neighborhood in violation of the CCNRs? Can you sue them for that? You bet. We did it once. Got them to take it all down. Cost them $3,000. Plus we got some attorney's fees and that. Oh well. We've covered the jurisdictional limits, who can file the small claims, and where you can file. Some rules about how this can come about. Let's see, how does The defendant, if the defendant wants to file a cross-complaint back against you, the defendant basically has to go through the same paperwork. File it, pay his fee, process server, serve it, file a declaration back with the court. Now we've got you joined. I love it. So, okay. Now, can you, by the way, get a waiver on fees? Yes, you can. But you have to be sort of destitute for that. Typically, though, they're not going to waive you unless you can show by a financial declaration you have no capability of paying the fee, but you're entitled to come into small claims court. And rightly so. Give me just a second here to make sure. Anybody have any questions? You know, we expect you to ask questions during the course of this class. So if you've got questions, raise your right hand, and I'll do my best to answer them. Go, miss. Yeah, I got both hands up already.
How do you find out if you're suing an entity, a store, how do you find out the right name of the person that you're
Good question.
going to?
That's a good question. All corporations are have to have at the Secretary of State's office. That's where you file your corporation paper. You have to name a person in there to be a receiver of the service of process. Okay, so let's say it's a telephone company. They would name CIT Corporation in Southern California. And you would serve CIT Corporation, have a process server, serve CIT Corporation with the documentations. CIT Corporation then forwards it to the company. Say, here you go, folks. Go defend it. So corporations have to have an agent for service of process. Partnerships sometimes do, sometimes don't. If partnership is registered but they don't have a service process designated agent, then you go after the general partner, a general partner. Okay.
That name again?
Secretary of State's office,
Secretary of State.
for the state of California. Just go online, and it's right there. It's pretty easy. That's always a problem though for students sometimes to find that. All right, now it's time to go through the venerable documents that I have. You do have a list?
Victor, I've got a question.
Okay, Bob.
In the service situation, it says on the documents that you gave us that if the defendant lives in the county, the process is 15 days, and I think you said 20 days.
Yeah,
So has that been changed?
that's been changed. That lengthened out, I believe, this year.
Okay, and then it says 20 days.
Right,
If it is outside
that's
the country,
right.
you say 30.
That's right.
So whoever's
Outside, yeah.
dealing with that should amend this.
Oh, yes. I'll amend it. I dealt with it. These are my documents. Thank you for bringing that to my attention. By the way, what if you get, this is a kind of a good example, too. Let's say you are a lumber company, and you sell lumber to somebody in Fairfield. That's down in Solano County, right? The lumber company files a lawsuit in this county. The defendant in Solano County says, hey, wait a minute, I'm down here. You have to bring the lawsuit down here. Lawsuits typically have to be brought in either the county where the defendant lives, or where the contract is entered into, or where the contract is to be performed, where the accident happens, so forth. Now, of course, this defense, he says, well, listen, you delivered the product down here, I'm down here, you have to sue me down in this county. Well, he doesn't. Why? Because payment is due in this county, here in Sacramento. That's when the contract is complete. So I'm here. So you have to come up here and defend the action. So typically what happens in these actions, particularly at the legal level, is we'll look at the county that most serves us as lawyers. I mean, that's the way we typically do it. All right, take a look at this documentation. There's pages numbered 1 through whatever, and we'll go through this. By the way, you can also, and I've done this too, file your small claims action online with a credit card. It makes it a lot easier than going over to the court. But you've got to follow the rules on the online, because that program can be a little bit, it wasn't designed for lawyers, it was designed for engineers over there. But anyway, you can file, and the way that happens is once you get the filing and get the program to accept your claim and your money, and there's a charge for using a Visa card or a MasterCard, a small charge, but over and above the filing fee, then you get back a note in an email that says your claim was accepted. Now, unless you are aware of that, you'll miss the whole thing. You'll think that because they come back with first of all, they'll come back with a date. Well, yes, your date is whenever. But they won't say that your claim has been accepted and that you now can print it off and go serve it. I had that happen to a client, and they missed that part. They didn't realize they were supposed to click on that little blue underlined word or something about the claim. And so the date for the court hearing comes and they don't appear. So they had to get it reset and so forth. Of course, in that particular case, the defendant objected strenuously. But well, better keep it to myself. Anyway, all right, page 1, authorization to appear. Similar to what I already told you about, that was also an authorization to appear. List the name and address of the person and position appearing. Who are you appearing for? Lawyers can come into a small claims action either on their own behalf or sometimes to advise, but they cannot really, they'll try to stand at the podium with the client. And I don't allow that. Also, in the insurance cases where you have personal injury action, the insurance companies will send a representative in, or the adjuster in, with the defendant for purposes of helping the defendant. They take the position that they are obligated by their contract of defense to help the defendant. Well, that's all fine and good, but what I typically ask these folks, were you a witness to the accident? No. Then why are you standing? Well, we're the State Farm insurance agent. We have a contract of defense. I says, fine. There's the audience. You may sit out there and not stand here. And then what happens is they will present to me a brief of papers. Looks like a legal brief on this case, signed by the defendant. When it comes to the defendant's turn to testify, first thing I'll ask them, I have a brief of papers from you. Did you prepare this document? No. I said, did you sign it? Yes. Did you read it? No. The insurance company prepared it. You got to get to the bottom of that stuff. Because if you don't, then they can get a leg up on the judge and the plaintiff. Also, in a typical action, particularly the personal injury auto accident cases, is you'll get these people that do videos. They'll have a formatted video that if you put in this certain kind of information, that, well, this is how the car was. This is why this defendant's not liable. They plug in certain parameters here, and so they'll attempt to show this is actually how the accident happened. And if you have a video to bring, we have facilities right there in the courtroom to show your video. And one time, I do recall this has probably been a couple of years ago, this defendant was so adamant about having his video shown, but from what I looked at, I thought it was something not quite right. So then I asked and he had the video guy there with him. I asked the video guy as a witness, did you put in, well, he put all the information in. I says, well, okay, that's fine. Show me the video. I mean, he was really adamant. I says, fine, show me the video. I just got sort of ticked. He shows me the video, and it looks like the accident happened, according to this video. It's kind of a mock-up kind of thing. You can put this information in there, show the speed of the car, and going around the corner, whatever, coming out like this. So then I asked the guy, I says, did you ask the plaintiff over here what their side of the facts are? No. Don't you think you should have had that to put this information into this video? Yes. Maybe. I don't know. Video's out. So you got to be careful. Don't try to do this over the judge's eyes. All right. Page 2 sets the trial date. This is part of the application. I'm going to assume that we did this sort of on the internet a little bit. Page 3. What did I do with my glasses? That's what you get for practicing law for 39 years. You have to wear these things. Okay, first part, number 1, on page 3, plaintiff. That's the person who's complaining. That's you. You need to fill in all that information that they require. The defendant is the person you're suing. They need that information. You need to remember to check this little box down here. Check if there are more than 2 defendants. And then you need to attach a 100A form. And here's how much you're claiming in item number 3. Now you've got to give an explanation. Oh, so-and-so hit me, damaged my car. Okay, fine. Where? What town are we talking about? What city are we in? Are we in this county? What date did this happen? So, what would you want to bring to me as your judge for the day or the half day regarding an auto accident if you're the plaintiff? You'd want to bring to me the highway patrol report. Uninterested observer, person that's tried, that is educated in the area of reconstruction of accidents, or a police department report. But oftentimes you run into the situation of where there is no policing agency. For example, in a shopping center lot like Arden Fair. They're not going to come on to that Arden Fair grounds and write up a police report. That's not a public property. You're there as a guest of Arden Fair. That's their property. They have security there. But unless security was standing right there, you know. So what would you do in as a substitute? Go. Yes?
Take some pictures.
Pictures. Pictures are still worth 1,000 words. And you take them from all angles. How about a diagram? A big enough diagram so that I can see where your cars are in this lot or on this street. You're plaintiff number 1, so you're going to be vehicle number 1. The other person's going to be vehicle number 2. Now, we also have in that courtroom a chalkboard where you have an intersection lines and so forth. We could let you go up there and place the cars. Well, this has happened here, this happened here. Bam, he got me. So you need to be pretty specific in this item number 3. At least tell me what city we're in, what date this happened, what intersection or street, and if you know the name of the cars, like, you know, what brand it is and so forth.
Would you mention where the damage is on the car? That would help?
Well, you might. You could say yes. You could say my left front or head on. You could say the guy hit me from behind. And we get a lot of those. But generally the defendant loses because they're following too close. Or I like this one. It's raining outside. They're still traveling just as fast as they do on a dry pavement. We're stopped in traffic. The person behind you is right on your bumper. Somebody hits him. Shoo, boom. Well, that wasn't my fault. The guy hit me back here, so that's why I hit you. Excuse me? You think you might have been following too close? You were. At least when you stopped, put a car length between the two of you.
Question. Now,
Go ahead.
Like on an HO, what you were using, Homeowners Association, if an individual brings an action about an illegal election, there is the state, there's a $500, that's what is, the fee.
Okay.
Is that what you would be putting down in here in regards to what is owed?
Yes.
And then you provide the information?
Yes.
That would,
Yes.
hopefully validate it.
Yes. That's what you would do.
Okay.
And you might want to say, and maybe there was some other costs too, so don't forget that.
Oh, there's duplication of information.
Yes, right, you know,
Records,
it's okay.
yeah.
Yes,
Let's say, for example, I was plaintiff and I put down that I went to a small claims class as a part of my research that, I want to recover that too, because I wouldn't be here if it wasn't for the fact that the guy hit me, say. Is that a
No.
cost or not?
not a cost. That's a great try, but not a cost. It's got to be associated with the accident. Now, could you bring a lawsuit twice on that same action? Let's say you lose the first time. Oh, well, I just forgot my police report. Can I bring a lawsuit on that same type of action? No. Same action, same parties, same accident. Mr. Schley.
I think it's important to point out that if you do have accidents or damage to some property, checking that box and attaching description of the damage and copies of the bills that you paid and things like that.
Yes, it is.
It brings
And not,
to definition.
well, not only that, but you're also required under the DMV code to file the SR1 or SR100, something like report. It's a notification it's a description of all the accident, whatever happened, and all of that type of thing. You have to file that. You can get tagged on that for not filing it. Okay? All right. And Mr. Schley is correct about all the peripheral information you need to provide the court in addition to the damages and location and so forth. All the costs that go along with it. What kind of costs could you have? Medical costs, the chiropractor costs, the doctor costs, transportation costs to get to the doctor. Maybe you have to have retraining costs. Maybe you have some costs, lost work. You might have a result. There, okay? Yes.
What if you're retired?
Pardon me?
What if you're retired? Out of luck?
If you're retired?
Yeah, no work costs.
No work costs? Well, yeah, I guess you'd be out of luck unless you can figure out a way to bring that in. I don't know. I'm not retired, so I can't tell you. But no, I would assume that you cannot take retirement costs. So, all right. Page number 4. What do we have here? You must ask the defendant to pay you before you sue. In other words, ma'am, your contract action for $1,000, you have to send the defendant a demand letter to pay. You're first, before you can get into the courthouse.
What if we're talking about the homeowners association?
Same thing, you have to send a demand letter. We want to know that you attempted to resolve it outside of the court system. In the personal injury case, you should, but I don't know that it's mandatory, but we take the position that it is, send a demand letter for your out-of-pocket costs, if you're the plaintiff in it, or including maybe your insurance costs, lawyer, some other fees, maybe investigation costs, that type of thing. You must send a demand letter for all your associated costs resulting from that accident when you got smacked. Sir.
Should your claim amount be identical to the amount that you claimed in your demand letter?
You've got to be a little careful about that because you've got to think, do I have some other associated costs that may be coming in down the line? Okay? If you do, you need to bring those in there within your bill. Because if you get asked about it, well, you can say, Judge, I had these associated other costs that are coming in. The bills are, and I've been told that there'll be this amount of money. Okay? You may want to, and then in your claim at the courthouse, you can make your claim for more than the actual amount because you may have left out a cost or something. Because if you plead $5,000 and I say, yes, you win, but you say, well, I've got $5,500 in a claim here. Too bad, you lost. So make your claim a little higher than the amount of the damages you're claiming. So just in case you find out or you determine that you had an additional amount of dollars over the 500 or over the 5,000, all right? Otherwise, we cannot award you anything more than you claim. We can, under a couple of circumstances. One, if the defendant is there and will waive that, but I have to advise the defendant, hey, defendant, will you allow the plaintiff to amend their claim to $5,500? I can't see a defendant doing that. But, or You say, defendant, we can continue this to another day and allow the plaintiff to present her evidence to you as to what the additional $500 is over and above the $5,000. Typically, defendants are not going to do that. Okay? So remember that to plead your case a little bit higher than the amount of your actual damages, because what's going to happen is I'm going to come back at you and you're in front of me, say, okay, what's your case about? And you tell me, and then I say, well, how do you get to $7,500 in this case? You're going to have, remember the itemization list? That's why you have it, because I want to be able to see where you're going with this. So you had another question.
Again, you had mentioned this earlier. For example, say your claim was for $10,000, but you are going to small claims court and the cap is $7,500.
Correct.
Do you submit the claim for $10,000 and the court says your limit is actually $7,500, or do you have to go with $7,500?
No, I will tell you, your limit's $7,500.
Okay, so when you submit your claim, even though it is more, you cannot even bring it in. So you have to cap it before you submit it.
Well, you can. Well, some people will try to file a claim for $10,000, and the clerks will argue with them, well, you can't get any more money than $7,500. But they will allow you to file that. But they're going to advise you, you're going to lose that upper $2,500. We'll tell you right now. And sure enough, that's what happens to them. But remember, this is a small claims court. People are not sophisticated about claims and caps and all that type of thing. So you had a question.
What if, for example, it is $10,000?
Mm-hmm.
You can show that you have several claims that total $10,000. Can you then bring multiple actions in order to recover, say, $3,500, $3,500, and
Arising out of the same set of facts?
same company?
No, same set of facts.
Yes.
Really?
Try that. Yeah.
Same set of facts, same people involved?
Yes.
You're still stuck with the $3,500 if you plead for that. Now, can you bring a second claim on that, whatever that action? I would say no. And the reason is you've got the same parties, you've got the same facts, you have the same incident, you have the same corporate part. There is some case law out there that would sort of allow you to do that. And I recall that Judge Patricia Wong had a case. I mean, she didn't have the case. A group of tenants had formed like a group and brought in several actions against this motel or something down on Stockton Boulevard for the decrepit nature of and how they'd complained and never got any redress. And so they did bring their actions serially, but you had different people. Each person had it. And then she merged all of them into like one big judgment, if I recall, something like that. But there are some exceptions in that area, but they're few and far between.
So if we tweak it slightly and say same party, but different set of facts on different dates.
Well, yeah, you can bring in another action. Because even the date, if the date changes, well, that's not yesterday, this is today. Okay? And you may have a different party involved. I mean, you cannot have the same party, same action, same facts, same amounts of money occurring at the same time. You're precluded if you've obtained a judgment, win, lose, or draw, win or lose.
All right. And then my other question, I have a company that specializes in working on judgments.
Mm-hmm.
So I take judgments on assignment. And I have several clients who have actions that they want to file in small claims court,
Mm-hmm.
but don't want to go through the process of attending themselves.
Mm-hmm.
They asked me if I can handle the attendance of the case. Assuming that I purchased the debt, I believe that I can.
I think you can too. Well, if you purchase the debt, but you've got to show that you purchased it, you've got to show an assignment, you've got to show a bill of sale, and you've got to show what the actual case is. But you're talking about a judgment, or you're talking to get to the judgment.
Correct.
You can do that. But some judges are not going to permit it because you're acting like sort of like a collection agency, and collection agencies are not allowed to come in and take assignments and file a lawsuit by statute. So you got to be careful there. Make sure you have your ducks in a row. Okay?
Yeah, one other question. I'm changed from an ADA to an ADA issue. Up here, it says that you must notify the defendant to make in regards to, let's say, of the violation, let's say it's a parking violation, and this company now, how long do you wait before you consider that they're not going to take action? You've written them this nice letter and told them that, you know, you need to have adequate.
You get 30 days.
adequate-
You get 30 days in my book. I don't care what the statute says. Time to bring the
Yeah,
action.
but you just stopped me there when you said, what, regardless of what the statute, this has always been a problem for ADA issues. They say,
Well,
somebody
what-
says, well, I'm going to be working on it, and that seems to go on, like you say, forever. I mean,
Well, now remember, the statute controls. I don't control that. But if the statute does not specify how long you have to wait for your demand letter to be answered or responded to or anything else, then I would say a 30-day time limit, because if you look at our whole statutory scheme, they're kind of based on 30 days for whatever it is, except for the government. Let's talk about a statute of limitations just for a minute. This is the way I learned it years ago. And Mr. Schley may need to help me out because I may be rusty about this. Really? She's cut me off. Gosh almighty, what is this? Wind it up, she says, for this part of the government statutes on limitation. What that means is when you have to bring your action, if you're going to bring an action, if you've been damaged in some way or another. Typically, if it's a real estate contract, a construction defect, 10 years. That's a pretty long time for a construction. Written contracts from the date of the breach, 4 years within which to bring your action. Personal property damage, 3 years. Oral contracts, that's where I loan you the $1,000, but we don't have anything in writing, 2 years from the date of the breach. And the date of the breach is when the date of payment is due and they don't pay after your 30-day demand. Personal injury actions went from 1 year to 2 years. Okay? The government claims, like the city of Sacramento County, I don't know about the state, I think the state's in there too. It's always been, in the past, when I was doing this kind of work, it was 6 months. You had to file a claim with that agency, and they have to either allow it to lapse, at which time, if they don't do anything, they've in effect rejected your claim, or if they give you a letter and say, well, we kind of like to work this out, but they're not really definite about it. Watch out for the 6 months because they're playing with it. The defense firms will also do that in personal injury cases. They'll play with it. They'll start lettering with you back and forth and attempt to negotiate and blah, 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 blah. You have to watch that statute. In personal injury cases, I think it's 2 years. It used to be 1 year, as between private individuals. You do not sue the insurance company in personal injury actions, like auto actions. We are not a direct claim state against the insurance company. You sue the party, the insurance company steps in to defend. They will provide you with the lawyer. Okay? I believe I left off with page 5 of the documentation. By the way, there was something I forgot to bring up in the last session. If a lawyer comes in to sue on a claim, of course, we lawyers who are individuals like myself, have an individual practice, we sue on our people that don't pay. We don't let it walk. Even if we're not going to collect any money, we're not going to let it walk. Because we want that person to tell the next person, hey, I got sued in on that fee bill. I want the reputation out there. You want my services? Get your checkbook out and don't bounce it on me, because I'll hit you with treble damages on the check. But anyway, if a lawyer comes in, the first thing that I ask, Mr. Lawyer or Miss Lawyer, did you file for arbitration with the Sacramento County Bar Association that is required under the Business and Professions Code 6200 et sec? If you did not, your claim is dropped. You have to do that first. You file a request for arbitration with the Sacramento County Bar. They have the form. The defendant has the right to respond. A hearing date is set generally before another legal counsel, and depending on that award, if you are the lawyer and you're awarded it, then you know the defendant's not going to pay, so take it to small claims court. Okay? But you have to clear that bar first. Very, very important. Okay? All right. Let's see, page 5. You got more than one plaintiff in this action? You need to list them. Same thing with the defendants. You need to list them. Now, I want you to take a look at the bottom. Item number 4. I have not filed and understand that I cannot file more than 2 small claims cases for more than $2,500 in California during this calendar year. They want you to tell the truth. Now, it says 2 more. It's not limited to just this county. You can file a small claims action here and small claims over in Solano County. Okay? And then, this is the one that most people violate. I declare under penalty of perjury, although I've not seen any prosecutions for under penalty of perjury in recent years, under California state law, that that's poor language, strike that. The information above and on any attachment to this form is true and correct. A lot of people just breeze on by. That can have significant effects. And a lawyer that gets caught at that lying, guess what? Their license will be hanging at the state bar's office in Sacramento if somebody wants to bring an action. Okay? All right. Fictitious business name, page number 6.
Before you get there, on the
Okay.
$2,500 in California that haven't filed, if you were serving people services on an hourly basis, and over a period of 8 months you've gone up to $20,000 in services and billed every month, etc., then could you file 2 claims against that person, one for $7,500 and then the next one for $7,500, even though it's the same person?
Good question. Can you split the claim? No. Because it all arose from the same contract. If you want to collect all your money, go to the Superior Court. File a claim downtown. And hopefully, if you're a good lawyer, you had them sign a fee contract. And you had an additional attorney fee clause in that contract so that you could get attorney fees by giving it to some person that you know to file it for you. Okay? You cannot split the claim. So just remember that.
Why is it on the front of the fee schedule, it implies that a person can have, 12 cases?
That's right. That's been updated. Look at the date at the bottom. That just came in this year.
It says 310.
That's right.
Oh.
January 1st, everything changes. Fees go up, new forms. You know, I just pulled that off.
But the number, they're saying.
I know they've increased that numbers of cases. This is what he's talking about here, is what I said on this particular form. This form is outdated in that sense.
I see.
Okay? So that's why I brought the fee schedule in, because I was surprised too. Oh, you can file this many claims? Well, that's kind of good. But can you split the claim?
So number 4, now we can?
Yes, you can.
Okay.
You can file more than one at a particular level. But you cannot exceed 12 in a year at that level. Okay? All right. They're trying to make money here. Let's get it right. Sir?
So can you file 12 claims for $7,500?
Yes. As long as it involves different sets of facts. So it doesn't mean that you couldn't have 12 claims against one person. You could have it, but let's say it happens in January, February, March, different set of facts each way, okay? All right. Now, we're on page 6. You're going to be suing under a fictitious business name, or you will be suing a person that has a fictitious business name. So you would say, John Doe, individually, and doing business as the ABC company. That's the way you'd state your... That way, then, you can get them individually and as a company. Typically, though, the companies are broke. But you got them. Okay? because the server, process server, is going to take that process out and hand it to him, one document, or you might do two documents, two sets, individually. Here you are, John. And by the way, here's for ABC, which you own. Okay? All right. The business does business as an individual, maybe, like a lot of us lawyers do. As an association, yes, that's possible. As a partnership, you can always go after the general partner. Corporation? Yep. Limited liability company? Yes. And by the way, that's kind of misleading, limited liability company. That doesn't limit, you could be the limited liability company, but that doesn't limit your liability. So if you have a car and you don't have any insurance on it, but you have it in the name of the limited liability company which you own, guess who's going to be liable? If you hit somebody, you are. Limited liability companies don't limit liability, except as to passive investors. But most liability companies, they're active. Okay, there was something else I wanted to bring up. Darn. Where are you going to file? You're going to file in this county. But what if your defendant's up in Placer County? We have a lot of people that and you're here. Can you file in this county? You bet. You want to make them come to your jurisdiction. Because I can tell you, you'll get a different result up in Placer County. I know of a very recent example over a sign contractor. Don't ask me why. I don't know. I guess it's because judges are human. They make some pretty nasty mistakes. But, so you're here, sue in this county. Don't go up there. I mean, you could go up there and file a lawsuit up there, but you got to go back and forth, and why? Make them come to you. Even if it's any other county, or Los Angeles County, make them come to you. If you produced sent them the goods from here to there, and they're to pay you here, the place of payment is the place that you do the lawsuit. You're here. You produced it here. Make them come to you. Okay? Let's see. What else do we have going down here? Do you need a lawyer? On appeal. If the defendant takes you up on an appeal, didn't like the judgment against them, can you have a lawyer at the appeals level? Yes, you both can have lawyers at the appeals level. Yes, the case will go from the beginning of the facts to the end of the facts. Can you put on evidence? Yes. Can the lawyer run your case for you? Yes. Not a good idea to have just yourself, but, you know, if you're probably, you kind of take your luck there. So you may want to pay your local counsel to come and, represent you. Do you have evidence there? Same evidence comes in. Same witnesses come in. It's all brand new bite at the apple, but this time you can have legal counsel. That's pretty good. Okay? All right. I've talked about, I think, getting ready for the court. Just your standard dress would be fine. No gum chewing. If you're going to chew gum, which we don't care if you do, be nice about it with your mouth closed. Because when we're judges, we're elevated up to here. We're looking down on you there, and we see some mouths that you could drive a truck through. And the gum, too. So, but just go standard. Don't dress up for it. If you're the defendant, take off the jewelry. My God, you got all these rings, and so I'd say you got some money. Take off the jewelry, ladies and men. Men are just as bad now about that. Okay, onward and upward. And by the way, the appeals probably will be set anywhere from 3 or 4 months out to 6 months away. So it's not an automatic and it's not quick. Okay? We also have out there very limited interpretation services. So if you speak another language other than our court language, i.e. English, you must bring your own interpreter. Boy, it can be hard sometimes to these cases when you have to work through an interpreter. Sometimes both sides have interpreters. Or sometimes you'll have a Vietnamese interpreter over here and a Chinese interpreter over here. Or Hispanic. I mean, it can look like it's mixed up, but it's not. It's just it takes a lot more time, and you have to be careful that interpreters interpret and not put their own inflection into how they think they heard the comments by the defendant or the judge. All right? So, okay. Instructions to the server, that's on page 9. Remember to give the server the appropriate information. The person's name, their address, what they look like generally, where they work, if they work, where they live, where they hang out, if you know. Those things. Servers are not, they're not, you know, they have to have something to work with. So, be good to your server, because it's going to cost you some money. Page 10. Here's the declaration that they have to fill out. Personal service. I personally gave copies of the documents to the person on whatever particular date, at, and the location, and so forth. Substituted service. They cannot find this guy. But they know he's in and around, he's hiding. But his wife is there. Well, you can serve his wife, subserve his wife after you've made 3 attempts to find John. Now in San Francisco County, they're kind of a little bit tricky about this. They give you a form over there, and how is that form? It has boxes that you fill in. I tried to serve John at 8 o'clock on such and such a day. Missed. Next day. You cannot try it 3 times in one day. You have to go over a period of days. Now they require 5 times. Typically we only require 3 up here. So, but they're real sticky about that. And if you don't have those boxes filled in just right, and with the times that you were there, the days you were there, and so forth. In other words, you can't try the middle of the night. It won't work. They want you to fill those boxes in correctly with the correct information. So, all right. Down here at the bottom of page 10, the server's information. They have to be very specific as to who they are. They have to make a statement that they're not related to you. They have to make a statement about how much they are charging. It must be reasonable. Because when you file your claim, you're going to ask for your costs, your court costs, your statutory court costs. Can you claim the lawyer that you went to see that told you to go file it in small claims court as a cost? Well, it is a cost to you, but it's not a cost that we recognize at the court. Okay? And the person cannot be under the age of 18. You believe it or not, people will try that. Proof of mailing. The server needs to send a notice, a proof of mailing that it was mailed to the defendant on a subservice. So, if I cannot hand you these if I'm the server and I cannot hand you these documents personally, but I can hand it to his wife or girlfriend or whoever after I've made 3 attempts, then I say, well, here's a summons and complaint for John Doe. And are you Mary Doe? She may or may not answer. She doesn't have to. But I need to observe her physical description. You know, 5'9" and beautiful, or whatever. And whatever ethnic they are, they may appear to be. And then you fill that in, as the process server, you fill out this declaration, but you also fill out a substitute declaration in the way of a process. You send this to the defendant with a copy of the summons that you subserved his wife instead, if you know that. All right? And all that original documentation must be filed back with the court. And you should, as a plaintiff, by the way, if the process server gives it to you to file with the court, make sure you file it before you come to the court, because it won't show in our computer record, and we'll say invalid service. But you'll say, oh no, I have the originals here. Then we'll take it, but we prefer that you file it at the clerk's office. Okay, what else are you going to need? Do you need some documents, maybe? You can get a subpoena for documents at the small claims at the same time that you file for your claim. That might be just very appropriate. if you're going to go to all the trouble of serving this person with a process server, with a complaint and the summons, then it's page 12. Then you should also, if you need documentation to help you prove your case, have the court issue you a subpoena for documents to have it served all at one time. So now you got a two-bagger. If they do not produce the documents within the time that's here, you can ask the court for continuance. You can now tell the defendant, and then let's say the defendant shows up without the document, court can tell them, go get the documents. And you're ordered to be back here by such and such a day. So if you have a case that requires documentation, serve this subpoena for documents with it. All right? Yes.
Post-judgment.
I'm getting there. I'm getting there. We're not through with this little pig yet. All right. In support of that subpoena, you have to fill out a declaration as to why you need those documents. That is on page 13. You just can't have any old documents. Are you entitled to the IRS returns?
No.
Well, I wouldn't be so sure about that. Yes. However, if I was the defendant and you wanted my IRS returns, I would say, well, documents are subject to the Fifth Amendment, so too bad. And I claim it. All right. All right, here we are. We got the proof. Oh, by the way, the process server has to file back a proof of service concerning the submission to the defendant of the subpoena for documents. Okay. Page 15. We want a court order and an answer. Can the defendant file an answer to the small claims action? No. This is not big boys court downtown, or as I call it, the court in the sky. So, what can you file? Can you file anything in defense of your claim? Typically, no. Unless you have obtained by a subpoena a sealed envelope with, say, records from the Department of Bureau of Automotive Repair. Those records come straight to the court. They come under a subpoena, and I'm the only one that can answer, or the judge is the only one that can open the envelope and see the docs. And there may be a report in there from the Bureau from the Bureau of the Automotive Repair for the state of California, and then you can examine that and determine whether you're going to let it in or not let it in. Typically, I let it in. I like to allow everything to come in, kitchen sink and all, because if everything can come in, then I've seen it all. I've seen why you maybe did this or did not do this, whatever. Remember, in any court action, whether it be the contract claim, the automobile claim, there's two things that you have to prove. One is the theory. You have to have facts that will set forth the theory of why you are entitled to this. And two, you have to have damages. Now, you can have the theory, let's say breach of contracts, that's a contract theory. Negligence in an automobile action is a negligence theory. Number two, you have to prove the damages. So you could have the right theory on yours, but no damages, because the defendant shows you that he paid you back. Or the defendant in the automobile case shows you that you have no damages because I wasn't the one that hit you. And that does happen. So you could have damages and no proof or theory, or the vice versa. But you always have to have those two together if you want to prevail. Theory plus the damages. Okay, they got to come together. Sir?
So for something like trespass, that's not going to make its way into small claims court?
It could.
How do you prove damages?
Good question. How do you prove damages? You could probably get an order out of them, ordering the defendant not to come back on your property. So, all right.
Can I bring the ADA issues?
Yes.
Because like you say, according to the UNRU, there's damages to be awarded. Then you have to prove everything that there's been no intent by the property or the business to make any changes. Do you list all these interactions before you arrive at court? I mean,
You would have to, if you were putting
to
it,
prevail, I guess.
yeah, in order to prevail, you would have to list all the things that would be, say, if the statute has certain requirements,
Right.
plus whatever else you did in order to assist yourself to resolve the issue. If after all of that you've shown me due diligence, okay? Now, question shifts back. So I've got that part. Now, you would also have to tell me how you're damaged. And you may come back and say to me, well, the damages are provided in the statute, $500. Okay? Let's assume that for a moment. However, the defendant would come back and say, well, this is what we did to ameliorate or alleviate this lady's problem as regarding ADA requirements, and we are in compliance. Here's an audit report that we just did this last year that says we are in compliance. Here's everything that they examined.
And if that's done, equals finished, then I could say there's really no reason to go to court.
No, but the defendant might be able to, if you were in the upper court, the defendant could possibly get attorney's fees against you.
Okay, if you were
Yeah.
working in
Yeah.
place.
So you've got to be there
Right.
with your case.
If it was filed in federal court, it would be different
Yeah.
than if we were talking about.
Yes,
complaint.
that's correct. That's correct. Somebody else? Yes, go ahead.
With regards to this form, I recently used this form in 2 applications, both post-judgment, one where it's an alter ego claim against the corporation, and I'm trying to bring the president of the corporation who is responsible for the judgment as well. And the judge's ruling was that all relevant parties are to appear, and were to appear on the 25th of March.
Mhm.
Okay? But I'm the assignee of the record, so does the original plaintiff have to appear, since I'm now the party that's bringing this motion against the corporation and president?
Did you buy the claim?
Yes.
Then you're the only one that appeared. The plaintiff, underlying plaintiff, doesn't have to appear unless they subpoena him in.
Okay.
Because you bought the claim from him, so too bad.
But the court still required the plaintiff's signature on the answer.
Well, then they must be treating you as a collection agency over there. Because I don't know, if you've bought the claim, it's your claim, you can do with it what you want. You can paper the bathroom wall with it, or you can file a lawsuit on it. And if the court requires, a signature of the plaintiff on the action?
Yes.
For what purpose? Why are you
You
doing?
can answer that question for me. They wanted the form, they sent it out to the plaintiff, they sent it to the...
Okay, what's the form say?
The answer,
Yeah?
all right, along with my pleading,
Okay.
and the plaintiff was to answer the question there that says, I agree with everything that's enclosed.
Okay.
And then the judge wrote in her answer saying all relevant parties are to appear on such and such a date.